Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama. After dark.
Hello, everyone. Again, it's me, Amos, doing her best to fill in for the amazing Llama so she can rest her voice. Today, we're going to be talking about day 9 of the trial for Virginia versus Christine Banfield. Court began this morning. I'm sorry. It wasn't this morning. It was Thursday morning. But court began with Commonwealth requesting permission to add an additional rebuttal witness to the list based on testimony given by the defendant the previous day. The prosecutor explained that the Commonwealth had been approached by an individual who claimed to have specific information directly contradicting a portion of the defense's testimony from the previous day. The Commonwealth stated that this information came as a surprise, as it had no prior knowledge of what the defendant would testify to and had not previously received this information from the proposed witness. The Commonwealth identified that the proposed rebuttal witness was named T. Patrick Smith and requested that he be added solely for rebuttal purposes. The defense counsel responded that they had not seen any information regarding this individual and requested an opportunity to review any investigatory reports or learn the basis of the witness's knowledge. The court indicated the defense counsel would discuss the matter with the prosecutor during a break and offered options on how the information could be shared. Court further stated that they would not object to the witness being added as a rebuttal witness. With that, they moved forward with Christine Banfield returning to the witness stand to continue his testimony under direct examination. Where Banfield picked up from the previous day, he had testified that on February 24th, 2023, he had not touched any electronic devices belonging to Christine, including her laptop or her phone. He also testified that he did not touch any devices belonging to anyone else. Banfield testified regarding the au pair arrangement with Juliana. I don't know how to say her last name, so we're just going to call her Juliana. He stated she worked through a company and was generally permitted to work up to approximately 45 hours per week. He testified her initial contract for 1 year was for 1 year, and that later it was extended for a second year, which would have ended in October of 2023. He stated that Juliana did not indicate any intent or ability to extend beyond that second year. He testified that Christine had handled all of the responsibilities about the contract and any communications, including paperwork, payments, decisions regarding visa extensions, and that he did not assist with that process. Banfield testified that after returning home from McDonald's, he saw Juliana and his daughter Valerie seated in his white Ford Fusion parked in the cul-de-sac near his driveway. He did not recall whether the car was running. He asked Juliana whether someone had entered the house, and she confirmed that a person had gone inside through the front door. Banfield instructed Juliana to remain in the car, which he understood to mean staying with Valerie. Banfield testified that he then walked partway down his driveway and observed a silver Jeep parked there and noticed that the front door of the house was closed. He stated that seeing the Jeep made him anxious and uncertain about what was happening. He testified at that point he believed that the situation might involve an affair, and did not believe it was a violent or threatening situation, and therefore did not consider calling 911. Rather than entering the house through the front door, Banfield testified that he walked across his yard toward the backyard to avoid the electronic front door lock, which he stated made a loud beeping and mechanical noises audible throughout the house. Why would you want to avoid that? That's suspicious. He testified that he did not want to alert anyone inside. Okay. He also testified that he briefly considered retrieving lunches for Juliana and Valerie and then leaving the house. He said that he unlocked the backyard gate, proceeded to the basement door, unlocked it with his key, that he typically kept the basement door locked and that it was not frequently used. Upon entering the basement, he observed that his dog, Lily, was present, which he described as unusual. He testified that Lily appeared frantic, jumping, spinning, whining, and vocalizing, which was inconsistent with her normal behavior. He also observed Lily's food bowl in the basement with food spilled on the floor, despite that the bowl normally was kept in the dining room on the main level. Banfield testified that Juliana and Valerie followed him to the basement without his instruction. He stated that he allowed them to enter the basement and close the door behind them. He testified that he conducted a brief search of the basement, including the main room and a bedroom, and did not locate anyone else there. He said that he then instructed Valerie to stay in the basement with Juliana and reassured her. Okay. Banfield testified that he left Juliana and Valerie in the basement, stepped over a baby gate blocking the stairs, and ascended to the main level of the house. He said that he closed the basement door behind him. I'm processing as I'm reading. He stated that he did not observe anyone on the main floor and conducted a brief visual check on the living room, kitchen, and dining room areas. He testified that while on the main floor, he heard sounds coming from upstairs. If you think somebody is in your house that shouldn't be, why would you just do a brief check? I mean, why wouldn't you call anyway? Clearly, I don't know what this man was thinking. Banfield testified that sounds initially appeared to be sexual in nature, including moaning and skin-on-skin contact, and he believed an affair was occurring. He testified that he did not consider calling 911 because he did not believe that the situation was an emergency. Okay. He stated that he was emotionally upset and considered leaving the house, retrieving the lunches, or going to work and addressing the situation later. I don't know about you, but if I was walking in on my significant other in an affair, I wouldn't just there would have been a confrontation. Banfield testified that the sounds then changed and became forceful, and that Christine's vocalization sounded painful rather than consensual. He testified that the spacing and nature of the sounds caused him to believe Christine might be in danger. At that point, he began ascending the stairs toward the second floor and unholstered his firearm while doing so. He observed the master bedroom partially open and determined that the sounds were coming from that area. As he ascended the stairs, he briefly observed Juliana on the stairs behind him, but did not give her any instruction and continued upward. Okay. Where was your daughter? Was your daughter with her? Banfield then testified he reached the second floor, turned left toward the master bedroom, and pushed open one of the double doors using his right foot while holding his firearm. Upon entering, he observed Christine and Joseph Ryan on the floor near the bed. Of the master bedroom. He testified that Christine was nude and on her hands and knees, and that Ryan was clothed, positioned behind her and looking directly at him. Banfield testified that he announced "police" immediately upon entering the room. He stated that he was holding his firearm visibly and that his badge was on his belt, though he did not know whether it was visible. He testified that Christine stated, "Brendan, he has a knife." Brendan then testified he did not initially see a weapon, but after Christine's statement, he observed a silver object in Ryan's right hand that was partially obscured by Christine's hair, which he later identified as a knife. God, how horrific. Banfield testified that Ryan was kneeling behind Christine and partially shielded by the bed. He ordered Ryan to drop the knife and let Christine go. Ryan responded by telling Banfield to drop his gun and stated that Christine was his and that she had given herself to him. Banfield testified that Christine vocalized and shifted position, which he interpreted as being injured. He said that he believed Ryan was stabbing Christine based on the movements he observed, although he could not clearly see her neck due to her hair. He testified that he observed what appeared to be a forceful stabbing motion towards Christine, followed by a downward stabbing stroke as Christine fell forward onto her stomach. At that point, Banfield just discharged his firearm at Ryan. He said he did not know exactly where he struck Ryan, but believed he made contact based on Ryan's movement backward. Banfield testified that he immediately moved towards Christine, stepped over her, and observed the knife on the floor for the first time unobstructed. He used his foot to drag the knife away from Ryan, moving it approximately 5 to 6 feet away. He said he did not touch Ryan at any point. Banfield testified that he then knelt beside Christine, who was rolling and holding her neck. He stated that Christine told him she could not see and asked him to apply pressure to her neck wound. He testified that he observed several severe injuries to her neck, applied pressure with his hands, and followed her instruction to increase pressure. He said that he later realized Christine also had wound on the opposite side of her neck. He instructed Juliana to call 911 and to watch Ryan. He stated that Juliana appeared stunned and initially did not respond. That Juliana went into the master bathroom without instruction, and he later realized she retrieved his personal firearm, a Glock 43X, from the gun safe. Banfield testified that Juliana fired a shot at Ryan while Banfield was tending to Christine. He said that he was struck in the shoulder from behind at approximately the same time, which he attributed to Ryan, though he did not see the strike occur. Okay, so he was being hit in the shoulder when Juliana was shooting at Ryan. Okay. Banfield testified that after the shot, he stood briefly, observed Ryan no longer moving, and then returned to Christine to continue rendering aid. He testified that he placed his duty weapon on the floor beside him while kneeling and continued applying pressure. He stated that Christine told him she was bleeding out, apologized, and said she loved him. Why would she apologize? Banfield testified that Juliana eventually placed the firearm she used on the bed. He said that he repeatedly instructed Juliana to call 911 and that she eventually began to call, but was initially unable to communicate effectively. Banfield testified that he spoke directly to the 911 operator, identifying himself as an officer, stating that a man had stabbed his wife and that he had shot the attacker, and providing his address. Banfield testified that while on the 911 call, he continued rendering aid, followed instruction to roll Christine onto her side to prevent choking, and used towels and bedding to apply pressures to her wound. He testified that Christine remained alive and breathing until first responders arrived. He testified that first responders instructed him to move into the master bathroom, where he sat on the edge of the tub. He described himself as panicked, shocked, hyperventilating, and physically unsteady. He said he later received medical evaluation in an ambulance. Banfield testified that Christine was still breathing and had a pulse when the first responders took over her care. He stated he did not leave her side from the time he resumed aid until responders arrived. Okay. So after he shot Joseph Ryan, he was at Christine's side until first responders got there. Okay. So he says. Banfield also testified that the decision to replace the windows in the home were made prior to any relationship with Juliana, and that all windows were upgraded to triple pane. He denied ever testing sound transmission by screaming outside the house, and testified that he only speculated afterward that the window may have affected neighbors' ability to hear gunshots. Banfield testified that his personal firearm was kept locked in a safe in the master bedroom, and that Juliana knew the code because it matched the home's door code. He testified that he did not know Juliana was retrieving the firearm until after she fired it. Banfield testified about travel plans discussed with Christine shortly before her death, including a planned cruise and a potential future trip to Punta Cana, however that is said. He testified that these decisions occurred while Christine was using her own laptop and that he did not access her laptop or phone. So you keep saying repeatedly. Banfield testified that he recorded audio of his dog Lily in 2024 at the request of Juliana's attorney to demonstrate the sounds Lily makes. He testified that the recording accurately reflects Lily's vocalizations. Oh, so now he can use this and recall his audio person to the stand because they just laid foundation for it. Banfield denied any knowledge of Christine using FetLife, Backpage, or Craigslist for sexual purposes, and testified that Craigslist had only been used years earlier for a yard sale. He testified that when he and Christine had differences in sexual frequency, he was never interested in sexual violence and never intended to harm her. He testified that he loved his wife and his daughter. He stated that he had no plan for the events on February 24th, 2023, and that he shot Joseph Ryan because he believed Ryan was attacking and stabbing Christine. That wraps up direct, and now we go into cross. So during cross-examination, the witness agreed that this was the first time he had told any story about what had happened in the bedroom on that day. Counsel pressed that he did not tell police at the house, in the driveway, at the hospital, or back at the station. The witness responded that he did on the 911 call and claimed that he was not questioned at the house, in the driveway, in the ambulance, or at the station. He testified police requested to speak with him at the hospital and later through his attorney, but he did not reach out to law enforcement on his own. And he said he offered through counsel to participate in any related civil investigation by his agency. The witness acknowledged his affair with Juliana began in August of 2022, that they took trips together, that they communicated on Discord, which he described as his preferred messaging app, and said his wife did not use it. He characterized their relationship as an affair and as a relationship, but not serious, and that there were times he told Juliana he loved her and that he had feelings for her, but they were not as strong as his feelings for his wife. The Commonwealth introduced Discord messages and multiple letters to Juliana. The witness recognized the letters the witness recognized the letters as his and agreed that they expressed love. He testified that he was definitely in love with Juliana starting in the summer of 2023 and said it was easier to fall in love with someone he believed saved his life that day. What the? One letter reinforced discussing future baby names. He maintained these strong feelings did not exist while his wife was alive and did not motivate him to kill her, adding that he and Juliana were not together when his wife died, and that he did not need to kill his wife to get Juliana back. I did watch that part of the testimony, and the prosecutor was like, so did you need to kill your wife in order to get Juliana back because you guys were broken up? I was like, go girl. Anyway, he also acknowledged multiple other affairs, including one with Danielle, which counsel characterized as originating on a site used to seek a sugar baby, and an affair counsel characterized as involving his friend's wife, which the witness disputed as their marital relationship status, while confirming he was married at the time. So he had an affair with somebody named Danielle that he met on a site seeking somebody. He wanted a sugar baby. He wanted to be their sugar daddy. Shut up. Couldn't that have been a fetish? Again, I don't mean to shame. I'm not shaming people. You have your things you like, but also, didn't he say that he never had been on any of those sites before in previous testimony? And he didn't know what they were? I'm going to have to go back. But then he also freaking had an affair with his friend's wife. Wow, what a stand-up dude. Counsel questioned the witness about evidence suggesting his wife's interest in arranging a fake rape scenario and whether there were any internet, phone, computer history before January 2023 showing such interest. The witness said he was aware she had been interested in that type of thing in the past, but was unaware she was pursuing it again until the message shown at trial. He agreed that, based on what he saw in court, the profile picture used appeared to be a photo taken that day, and he could not say what other photos were available. I think that's written wrong. Anyway, he testified he did not know whether the plan required a public meetup first, and said he did not read other people's messages. He also testified he did not see and ask for the knife. He acknowledged he knew his wife had a blood clotting disorder, but said his experience was she did not require medication during pregnancy and would be monitored during delivery. Okay, that doesn't make it any better, sir. You knew about this. Whatever. Oh, goodness. Counsel walked through the morning timeline. The witness left the house, went to McDonald's, spent about 7 minutes in the bathroom, received a call from Juliana around 7:37, testified he did not call 911 for McDonald's and did not tell Juliana to call 911 then, explaining he initially thought the situation might involve his wife having an affair and said he wasn't sure what was happening. He testified he returned home. Juliana brought his child into the basement after him, and he believed they were safe there and not in any danger. He acknowledged he did not tell Juliana to take his child away and later agreed it may have been a mistake. You think, sir? Even if you thought your wife was having an affair, and that might be what you're walking into, and your au pair comes in the house after you, even though you've told her not to, and she has your daughter with her. You wouldn't want your daughter to see that either, would you? Or to hear an argument that might come from that if you confronted the situation. So, bad call all the way around, although I have my other opinions on that. But anyway, he testified that initially he thought he heard sex noises, but as he climbed the stairs, his interpretation changed because the sound seemed sharper, like strikes. Counsel asked about a lock on the basement door. The witness said he did not think he had ever used it and did not think of it at the time. He testified he went upstairs with the gun drawn, saw Juliana on the main floor near the front door, and said he did not call her to call 911 or go back downstairs because he was moving quickly toward the bedroom and focused on his wife. He testified he did not think about his daughter at that moment because he believed his wife was being injured. Okay, so again, your child is there with your babysitter on the main floor. You're running to what you thought now your wife was being hurt, and you still didn't tell her to call 911 or leave the house. I don't know about that. In describing the bedroom entry, the witness testified he saw Joe Ryan behind his naked wife with something metal in Ryan's hand and yelled, "Police," but did not shoot immediately. He testified he did not know Ryan's plan. Commonwealth introduced some exhibit, and counsel questioned how Ryan could have planned an attack despite leaving an online trail. The witness said he had no idea what Ryan's plans were and suggested Ryan's actions appeared related to the witness saying he would arrest him. Okay. Counsel challenged the witness account of the stabbing sequence. The witness testified he believed his wife already had blood in her hair when he entered, and that he was only certain of seeing 2 stabs. One when he saw a forceful stabbing after an exchange, and another downward motion after she hit the floor. He said he could not account for the remaining wounds and could not say what happened before he arrived. He agreed that the medical examiner's testimony was that she was stabbed 7 times plus an additional cutting wound. And counsel showed previous admitted wound. Counsel then showed him the injuries. I pulled up the picture. The witness testified his wife spoke to him despite difficulty, including saying Ryan had a knife, instructing him on hand placement, pressure, and later saying she could not see. Don't forget, she said she loved him and that she was sorry, too. With the injuries that this woman had, I highly doubt she was speaking. Counsel highlighted that Ryan stopped at Walmart and purchased personal lubricant, and that no semen DNA from Ryan was found in or around the wife's genital area, which the witness said was his understanding as well. The witness estimated less than a minute passed between his commands for Ryan to drop the knife, let her go, and the shooting. He testified he did not shoot before his wife went to the floor, said he was afraid, and stated his shooting qualification record was on the lower end, and he feared hitting his wife due to limited space. He agreed Ryan did not have a gun, to his knowledge, and that he had handcuffs but did not use them, adding that in hindsight, he should have handcuffed Ryan after the shot. Sorry. On firearms practice, the witness testified he went to a range roughly Cut potatoes. I messed that one up. On firearms practice, the witness testified he went to a range roughly monthly or every other month when he could, but described using Blackfish Armory previously due to a contract and said it later went out of business. He said he then went to Silver Eagle Group, but did not recall the exact transition and timing. He testified he taught Juliana to shoot as an activity they could do together. Oh, can't see my eyes, but I'm sort of getting some side-eye on that one. Questions, counsel questions, safe and door codes. The witness testified Juliana knew his code because it was the same across his door, safe, and car safe, and because she observed him entering it. He also testified other household members had their own door codes. He said he did not change the code after initial setup and did not view that as a concern. And he said he was aware of other officers' families, members knew their codes. Okay, so just because they did it, it's okay for you to as well. It doesn't seem like a very well-trained officer, in my opinion. Finally, counsel questioned life-saving steps on the 911 call. The witness testified his training indicated Juliana should call 911 when he attended to his wife, and he said he believed he told Juliana to call 911, but was focused on his wife and did not realize Juliana had not called immediately. He testified he did not hear or see Juliana make the original 911 call, and said he did not know about the call until much later, believing it occurred in the basement. Counsel asked about using towels, blankets, sheets to staunch the bleeding, and the witness testified he applied direct pressure and did not use the cloth items until instructed by 911. And he confirmed the wound was large enough that his finger went inside it. He agreed video showed him holding her neck with his bare hands when first responders arrived, and he was unsure where the towel or blanket and sheets were at that point. Counsel ended cross-examination with nothing further. Wow. So those were his direct and then cross. Outside of the jury presence, the court was informed that during a break in proceedings, a man approached one of the detectives in the presence of two jurors and asked whether it was too late for him to testify. The detective immediately instructed the individual to stop speaking and walked away from him. The interaction ended at that point. It was noted that the brief exchange would have been overheard by 2 jurors present. Following this disclosure, counsel requested to approach the bench. After the sidebar, the court confirmed readiness to proceed, and the jury was brought back into the courtroom. So we don't really know what happened there, but a conversation took place. Anyway. So on redirect examination, Brendan Banfield testified regarding the timing of circumstances surrounding the decision to call 911. He stated that once he entered the room and that he confronted Joe Ryan, he realized that calling 911 would be necessary. He testified that at that point, he was not capable of calling 911 himself because his hands were on his firearm. He confirmed that this realization occurred after he had already confronted Ryan. He testified later, while rendering aid, he instructed Juliana to call 911. When asked why he did not call himself at the time, Banfield stated that he was, I just said that. I'm so sorry. Woo! Banfield was then asked to elaborate on prior testimony concerning whether he was aware of Christine's engaging in fetish-related behavior. He testified that while living in New York, Christine had been involved in an extramarital affair that included a BDSM relationship lasting approximately 1 or 2 months. He stated that he became aware of this affair after observing multiple bruises on Christine's body while she was in their bedroom, injuries he had not previously known about. He testified that he had confronted her about the bruises and suggested that they return to therapy, questioning her enjoyment in the activity. He described the conversation as emotional. Banfield tested that he was aware of Christine's exposure to sexual violence through her professional work as a sexual assault nurse examiner, which he estimated occurred between approximately 2012 and 2017 or 2018. He stated that she conducted examinations of individuals who had been choked or raped, and that she sometimes brought documents related to the work home, which he observed her reviewing. What? I call bullshit on that. But that's my opinion. Don't hate me. He testified that the New York incident involving the BDSM relationship occurred around 2014, and that they attended counseling approximately in 2013 and again in 2014. When asked whether there were any similar instances, Banfield testified that he was aware of another brief relationship in which Christine was stalked for a few weeks. He stated that he was not aware of any injuries resulting from that situation. Where's the proof of any of this? Regarding the earlier BDSM-related incident, Banfield tested that Christine had significant bruising to her legs, buttocks, and chest. He also testified that she had difficulty walking and walked stiffly during that period. Banfield was asked about statements he made in letters referring to Juliana as a hero. Oh, good God. He testified that he believed Joe Ryan remained a threat to everyone in that house. He stated that when Ryan got up and struck him, both his firearm and a knife were on the floor, creating the potential for Ryan to access them. Banfield testified that he believed Juliana's actions potentially saved the lives of others in that house. He testified regarding the status of his relationship with Juliana prior to February 24th, 2023. He stated that the relationship had ended prior to that date and described the situation as complicated. He testified that tensions increased after he and Christine went on a cruise in November, and that Juliana did not spend Christmas with him and his family, and that by February she had indicated she was returning to dating apps, which he understood to mean their relationship was over. He said that as of February 24th of 2023, he and Juliana were not in a relationship. Finally, Banfield testified regarding his decision to shoot Joe Ryan. When asked what he thought at the time he made that decision, Banfield testified that he believed Ryan was an imminent danger and threat to Christine and the others in the house, and that shooting him was the best way to stop his actions. The defense then rested. Next up, they called Nick Barrerio, who is the audio sound person that had previously been on the stand via remote, and they had to cut that off because he didn't have foundation to talk about what they were going to talk about. And so now he's back to talk about it. So the court resumed with this remote witness. And once they were connected, the witness confirmed he could hear blah, 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 that he remained under oath. So they resumed direct examination where it was left off. Mr. Barrero testified regarding his audio forensic methodology. He explained that his analysis relies on critical listening, waveform analysis, and spectrographic analysis. He described critical listening as repeated, detailed auditory review of evidence using professional headphones on a forensic workstation. He explained that waveform analysis provides a visual representation of sound amplitude over time, while spectrographic analysis displays both amplitude and frequency, allowing individual frequency components of sound to be examined visually. This is probably going to be way over my head. I'm just going to be real. Mr. Barrera explained that spectrogram can reveal audio details they may not easily be perceived by the human ear, particularly in the presence of noise or overlapping sounds, and provides objective measurements for comparison. He testified about fundamental frequency, describing it as the lowest frequency of sound and the perceived pitch, and explained that the formats give a sound its unique characteristics. He used the example of different instruments playing the same musical note, but sounding different due to their overtones. Okay, that I get. Mr. Barrero testified that he analyzed 2 audio items admitted into evidence, the known 911 call, which is the first one that was hung up and nobody spoke, and then an exhibit titled Lily 3 Original, which is an audio recording of a dog named Lily, which Brendan testified to in his testimony. Regarding the 911 call, he testified that he isolated a specific sound occurring approximately 1.4 seconds after the dispatcher answered. He stated that this 1.4 second segment was the sole portion of the 911 call used in his analysis. He explained that the sound was very clearly identifiable both audibly and visually in the spectrogram, showing a fundamental frequency and distinct formants. He then described isolating a comparable groaning segment from Lily's recording. Mr. Barrero testified that the fundamental frequencies of both the question sound in the 911 call and the Lily exemplar were in the low 200 hertz range, which formants stacked above the fundamental frequency in both recordings. He then testified he compared the isolated segments side by side, focusing both on the fundamental frequency and the first 2 formants, which he stated had the highest amplitude in both samples. I don't know about you, but this is all just sounding a little, woo, okay, fine, whatever. Just give me the cliff notes. Unfortunately, I don't have those, but anyway. He testified that the frequencies and formant structures aligned consistent between the two recordings. Okay, so he compared Lily's moaning and the moaning on the 911 call and said that they're the same, or they could be the same. As a result of his analysis, Mr. Barrio testified he created I cannot say that word. You're just going to have to trust me that it's a word, and words are hard, people. Anyway, this audio file is titled Exemplar 911, which placed the isolated 911 sound and the Lily exemplar back to back for auditory and visual comparison. He testified that when he played sequentially, the two sounds were audibly and visually consistent. And then this file was admitted into evidence and was played for the court. He testified that although it is theoretically possible for two sounds to share the same pitch momentarily by chance in a long recording, his analysis did not rely solely on matching pitch. He emphasized the full set of formants and overtones, which give a sound its unique character, were consistent between the two samples. Again, okay, so everything that he's testifying to is that the sound of Lily moaning and the sound of the moan on the 911 call, all of his study says that they are consistently the same, or could be the same. His conclusion would not change regardless of whether he was retained by the defense or the prosecution, stating that his analysis was based solely on objective data and that he considered himself an advocate for the evidence, not either party. Well, of course you would say that. Okay. On cross-examination, the Commonwealth questioned whether the sound on the 911 call could have been a human in origin, to which Mr. Barrio agreed it was possible. He acknowledged that the Lily recording was significantly longer and the 1.4 second clip, 911 clip, and that he had been provided only the Lily 3 recording, not other Lily samples. He disagreed with the characterization that he identified a single 6-second match out of thousands of seconds, explaining that only a few brief segments of Lily recording contained groaning sounds at all. On redirect, Mr. Barrio testified that the Lily 3 recording was nearly an hour long and consistently largely of silence, background noise, barking, whining, and only a few groaning sounds. Okay, yeah, he already said that. Thanks. He testified that in selecting an exemplar, he specifically looked for sounds comparable to the groaning heard on the 911 call and did not compare dissimilar sounds such as barking. He testified that no one directed him to any specific segment of the Lily recording and that he independently selected the portion used for comparison. And that concluded his testimony, and he was excused. Next, we have Detective Stephen Augustine. Detective Stephen Augustine. The Commonwealth called Augustine, who was sworn and testified. He's had 24 years in law enforcement experience, including 20 years with the Fairfax County Police Department and 12 years as a detective assigned to the Technical Investigations Unit Forensic Audio Video Section. He stated that he holds a master's degree in audio technology and a master's degree in forensic science and previously taught audio technology, electronics, and digital audio at American University. He indicated he had previously testified as an expert in forensics audio and video analysis and was accepted by the court as an expert in forensic audio analysis. Detective Augustine testified that he was familiar with concepts discussed by the defense audio expert, including waveform and spectrograph analysis, fundamental frequency, and harmonics. He explained that spectrographic analysis is a tool used to visually represent sound, but that not all forensic audio examinations require it. He stated that the waveform analysis and critical listening are commonly used methods in forensic audio analysis, and the fundamental frequency principles are significantly accepted and regularly applied in his work. He testified that in this case, he did not conduct an independent forensic comparison of known samples. Instead, he was asked by the Commonwealth to review and comment on the defense expert's report and demonstrative materials. He stated that his role was limited to reviewing the defense's expert work and offering opinion on what was presented. Upon reviewing the defense's expert material, Detective Augustine said that the defense expert did not conclude the two samples were a match, but rather described them as consistent. Augustine stated he agreed that the samples could be described as consistent, but believed additional explanation was necessary. Augustine identified a defense demonstrative consisting of concentration. I'm sorry. I got to get this word because apparently it's going to come up again. It's called concatenation, and it's stitching together, apparently, of two different audio files. The exemplar and the segment from the 911 call displayed using the spectrograph. I say, yeah, spectrograph. Okay. Words are hard, people. He testified that the demonstrative and visually showed fundamental frequency and overtones, which would be expected in sounds with a fundamental frequency of approximately 200 megahertz. He explained that multiple audio sources can appear visually similar when they share the same fundamental frequencies and harmonics, and that this similarity alone is not unusual. He further stated that the demonstrative involving combining a 6-second exemplar with approximately 1.4 second from the 911 call, that the waveform, he did not observe a clear boundary between the two clips and opined that a crossfade technique was likely used. He explained that a crossfade causes one sound to fade out as another fades in, creating the impression of a continuous audio file. He said that without a crossfade, a listener would hear the full exemplar, a clear transition point, and then a separate 911 audio, allowing for a clearer comparison. Detective Augustine testified he was first asked to examine the audio files in September of 29th of 2025. So, just recently, relatively, approximately a year and a half to 2 years after the murders. He stated that he was not provided background information about the 911 call and did not know what specific sounds or voices he was expected to hear when he began his review. He testified that he analyzed the 911 hang-up using Avid Pro Tools software, conducting waveform analysis and critical listening. During the analysis, Detective Augustine said that he observed sounds on the waveform prior to the audible groaning on the 911 call. Oh, okay. He stated that he isolated a portion of the audio, increased the volume, and heard what he believed to be a human voice prior to the groaning. What? Shut the hell up. He testified that he perceived the sound as a human voice and identified what he heard was questioned by the Commonwealth. So what were the words? On cross-examination, Detective Augustine acknowledged that the spectrograph image he discussed was created by the defense expert and that he does not routinely rely on spectrographic analysis in his own work, though he is familiar with it. He testified that he did not prepare his own independent report and was not asked to, explaining that he was serving as a rebuttal witness, reviewing and commenting on defense report expert findings rather than conducting a separate analysis, which, from what I understand, is not unusual when you are a rebuttal witness. That's just what I know, being a nerd. He stated he has the capacity to perform a full independent analysis if requested. There was no redirect examination, and he was excused. I will tell you that I do know they wanted him to say what he heard the voice say, but it was objected. There was a sidebar, and he then had to. It was the judge says, no, you can't do it. So we don't know what was said. But did I so nerdly try to hear it myself? I did, but I'm not audio, visual, or what. I'm no audio expert. I don't know what I'm doing, so I didn't get anything from it. I'm hoping somebody will, and that I'll find it online somewhere, some point. And if you know where it is, leave us a message in the comments, please. So next up is Thomas Patrick Smith. This is the witness that was added as a rebuttal last minute. Thomas Patrick Smith testified he is a special agent with the IRS Criminal Investigation and previously worked with Brendan Banfield at the Vienna, Virginia office. He stated that from February 15th through February 24th, 2023, he served as the acting supervisory special agent at the Vienna group because the permanent supervisor, Julia Jones, was out of the country. During that period, Banfield reported to Smith. Smith explained that the IRS practice allows for designation of an acting supervisor when the permanent supervisor is unavailable. Smith testified that on the morning of February 24, 2023, he was in Baltimore assisting with an unrelated undercover operation and had no plans to meet with Banfield that day. If you guys remember, Banfield said that he was going to be meeting with his superior boss or manager or something that morning of the murders. And now this guy who was his acting supervisor said he didn't have any meeting scheduled with him. He stated that Julia Jones was still out of the country and that a high-level supervisor, assistant special agent in charge, David Meisenheimer, and special agent in charge, Kareem Carter, were also out of the state at the time. So which boss did you meet with, or were you going to be meeting with, Mr. Banfield? Smith testified he did not speak with Banfield on the morning of February 24th and was not scheduled to meet with him. He was surprised when he had later received a phone call informing him that Banfield had just discharged his firearm and that 2 people were deceased. He testified that as an acting supervisor, this required him to notify upper management and initiate internal procedures, including contacting the Treasury Inspector General for Tax Administration, which investigates firearm discharges by IRS agents to determine whether they were appropriate. That sounds pretty legit to me. Smith testified regarding professional dress expectations within the IRS criminal investigation, stating that for important meetings, he would wear formal or semi-formal attire, such as a suit, tie, and dress slacks, and that he would not ever wear jeans or sneakers to such meetings. On cross-examination, Smith clarified that he was designated acting supervisor during Julia Jones's absence and that such designation would typically involve management approval. He acknowledged that the incident created additional work in the form of required notification and communications. He said that he spoke with the Fairfax County Police after the incident, but could not recall the name of the detective he spoke with. He stated that the information he provided to upper management would likely be documented in emails. He confirmed that he remained permanently assigned to the Vienna office before and after February 24th of 2023. Smith acknowledged awareness that multiple IRS agents from the Vienna office were interviewed by Fairfax County Police in connection with this case, including David Meisenheimer, Lawrence Flagg, Philip Hammond, and others, though he testified he was not present for those interviews and did not know their specific content. He stated that he was out of town during the week those interviews occurred and was not interviewed himself, despite having been the acting supervisor during the relevant period. Smith testified that Lawrence Flagg was not Banfield's supervisor. He stated that he had frequent contact with Flagg on February 24th of 2023 due to the incident, but could not recall the frequency of contact prior to that date. On redirect, Smith reiterated that the only individual who could have been considered Banfield's manager at the time were himself or Julia Jones, and that Julia Jones was out of the country, and that Smith was in Baltimore, and not planning to meet with Banfield on the morning of February 24th of 2023. That ended the redirect. Defense had piped in and asked if they could ask one more question, and the judge said, no, sorry, not going to happen. And so that was the end of his testimony, and he was released. Out of the presence of the jury and the plan for the next day, defense counsel John Carroll renewed his motion to strike, arguing that even when viewed in the light most favorable to the Commonwealth, the evidence was insufficient to sustain the charges. He asserted that the Commonwealth's case relied almost entirely on the testimony of the co-defendant, which he argued lack of credibility, detail, and consistency when subject to cross-examination. Carroll emphasized that the case involved complex forensic evidence, digital forensics, bloodstain pattern analysis, and timing evidence that he argued would devoid the necessary detail and internally conflicting. He further argued that the co-defendant was able or unwilling to answer detailed questions beyond the narrative presented during direct examination, and that her testimony conflicted with the testimony from multiple Commonwealth witnesses, including Detective Brendan Miller. He contended that co-defendant's timing in coming forward coincided with her own legal proceedings, health issues, and perceived loss of confidence in her counsel, undermined her credit. That those all undermined her credibility. Carroll also renewed his motion to dismiss under NAPU, asserting that the co-defendant's testimony was demonstrably untruthful. I don't think that's for you, sir. I think that that's what the jury has to determine. But the Commonwealth responded that it had met its burden of proof and that the case was appropriate for submission to the jury. The court denied both renewed motions to strike and the NAPU, I don't know if I'm saying that right, and I'm sorry if I'm not saying it correct, motion to dismiss. Just stating without weighing credibility, there was sufficient evidence as a matter of law on each count to allow the case to proceed to the jury, and that the weight and credibility of the evidence were matters for the jury to determine. That's what I thought. Following these rulings, the parties addressed charging decisions and jury instructions, and the Commonwealth elected to proceed on aggravated. Okay, we're not going to go over all of that, but they are going to go through and look at all of the charges, and they were all upheld as far as none of them were going to be changed. So the court agreed to defer final resolution of the aggravated. Okay, so they're going to meet prior to court the next morning at 9 a.m. to confer and attempt to resolve any of the issues that they have had, which I did not outline, and I'm sure you can find it somewhere else if you want to find it, but it's probably typical arguments between counsel at this point in a trial. Okay. Before adjourning, the court addressed administrative matters, including notifying the jail that a witness was no longer required to remain segregated and could be returned. The court then recessed for the day and scheduled proceedings. And proceedings are scheduled to resume the next morning, which would have been Friday morning, which I know did happen because this has been recorded after. And we are going to do another recording of those closing arguments. after this. So, I don't know. I can share my thoughts briefly in just that I think that reading these and watching the testimony is definitely a whole different thing. And seeing mannerisms and, this guy did plenty of eye rolling and there was smirking and I don't know, you just need to see it to kind of get a good feel of his testimony in regards to Banfield for sure. So I think that he's in trouble. I don't think that the jury's going to come back in his favor, but that's just my opinion. So why don't you let us know what you think in the comments if you've watched any or just hearing what we've had to share with you. On that note, we'll close out the session for today and just say thank you all for listening. And, with me and all my chaos, because I'm not a very good speaker, especially when I know that I don't have to read something. Oh God, I'm already messing this up. Anyway, thank you all for listening. Don't forget to hit the like and subscribe and come back for more of our chaos and court coverage and TMI and all of the fun things on our channel. We appreciate you all so, so very much. And with that, keep an eye out for anything amiss and stay amazing. Good night, everyone.